All right. Hello and welcome back to another edition of the Michigan Journal of International Law podcast. I'm Ryan Shaw, a current 3L and managing articles editor of the journal. I'm excited to be joined today by Dr. Damian Gonzalez-Salzberg of the University of Birmingham in England. Professor Gonzalez-Salzberg is a scholar of international human rights law and has focused extensively on empirical research into the machinations of international tribunals, such as the International Court of Justice, the Inter-American Court of Human Rights, and the European Court of Human Rights. His latest article with Owen Campbell is titled Insistent Objectors: The Abuse of Procedural Defenses Before the International Court of Justice. We at MJIL are thrilled to be publishing the piece in issue 2 of this year's journal and are looking forward to today's discussion. Dr. Gonzalez-Salzberg, welcome to the MJIL podcast.
Hi, Ryan. Thank you so much for having me, and please call me Damien.
Great. Well, we're going to start, Damien, with a little bit of your background as we're doing with our authors. I'm curious just to know a little bit about how you first became interested in international law and whether you had any kind of sources of inspiration or mentors when you were a young law student and thinking about practicing in the area.
Yes, I actually did my first law degree at the University of Buenos Aires in Argentina. And back there, I don't know if it's still the case, this was over 20 years ago. But then public international law was a mandatory course, which is probably not that usually in many law schools. I know it is not in the places that I teach. And I had fantastic professors in the area. And actually, when when you did a degree in Buenos Aires, you had a sort of the equivalent of a BA for the first part of your career. And before you graduate, which you graduate already as a lawyer, you need to pick a specialization. And I picked as my specialization public international law. And I was very, very happy to do that. And part of these had to do with two amazing professors that I had through my degree, in particular in international law. I had the privilege of having a diplomat who was a legal counsel for the Ministry of Foreign Affairs, whose name is Holger Martinsen. I think he's an ambassador now somewhere in the world. He was incredibly passionate about international law and that was really infectious. And then I had the absolute privilege to be a student for a little bit in public international law, but mostly in international protection of human rights of Professor Monica Pinto, who's probably one of the biggest international law scholars that Argentina has produced. And again, like when you have people like them teaching you, it's almost impossible not to fall in love with the discipline. So that's how I ended up specializing in international law.
And you mentioned a little bit about coming from Argentina, which is, a place that in the area of international human rights law and public international law generally just has a very rich, complex but fascinating history in the areas of you had the trial of the juntas in the 80s, and kind of the first domestic court system to prosecute a former dictatorship in there. So what does it kind of mean to be an international human rights scholar from Argentina, and how has the history of the country kind of shaped your understanding of the subject matter?
You actually are pointing out two very, very important developments that completely shaped the way or the reasons why I fell in love with this area. I was born towards the end of the dictatorship, as you mentioned, had committed terrible, gross violations of human rights, and Argentina had the privilege to actually prosecute in the mid 80s the people, the most responsible people for some of these violations committed. But at the same time, this very act of bravery in an incipient or recovered democracy was followed by pseudo amnesty laws that and presidential pardons subsequently that determined that very, very few people actually had been found guilty of the terrible crimes that had been committed. And at the time I was in law school, actually, there had been developments that meant that some of these prosecutions were actually reopening. And this was incredibly influential for me and I think for my generation to think about the value of international human rights in this development of justice in our country. Because one of the, not the only one, but one of the main influences in the reopening of these trials in the 2000s had to do with the developing jurisprudence of the organs of the Inter-American human rights system, the Commission and especially the court. So I think that it became very significant for my generation that the value that we could see international human rights law having in the domestic jurisdiction. So that had a huge impact in deciding to specialize in that particular branch of international law as well.
And in addition to your article with MJIL, which focused on the ICJ, you are also the author of an international human rights law textbook, and kind of sticking with Latin America here with the legendary former ICJ judge Cansado Trindade. I'm curious what your time with him was like as a colleague and an individual, and what you learned from your time with him.
It was an incredible and unique privilege to have been able to work with Judge Cansado Trindade in that book. Linked to the previous question, although I learned from these amazing professors that I had in the at the University of Buenos Aires with regards to international human rights law, my generation learned a lot from the jurisprudence that the Inter-American Court was developing, in which Antonio was an leading voice, including the many separate opinions that he had rendered during his time at the court. So obviously, for me, there could not have been a bigger honor than to work with somebody like him. As you probably know, sadly, Antonio died while we're still working on the book. He died at the end of May 2022. And that also opened up the possibility of writing a little bit about my experience with working with him in the preface of the book that can be accessed. I did a short narrative as to what it had been, the journey that had we started. Well, the idea started even a few years before, and I'll tell a little bit about that in the book. But with the writing starting already in 2020 about that, and I actually also did another podcast on that in particular for the Human Rights Center of the University of Buenos Aires, in which we talk quite at length about the experience of working with Antonio. But what I can say is I don't think I have met a scholar that had been so incredible, generous and inspiring as Antonio in my life, and I don't think I will.
Well, moving into your article with Owen a little bit, I was impressed at the kind of level of rigor of empirical research that it seems like you've dedicated to a lot of your scholarship. And I think lawyers and practitioners and scholars are often kind of wary of wading deep into kind of statistics and numbers. But you do just that here, and you kind of survey uh, you know. Uh, what all of the kind of procedural defenses to cases before the ICJ have been throughout its history since the end of World War II when it was established. Why do you think empirical research is essential to understanding how legal systems like international tribunals like the ICJ work, and kind of what's the value that's derived from that?
Let me say two things. One is very true. Lawyers do not usually venture into quantitative research, and the problem has to do that we are not trained in doing this. Law school, at least in the law schools I have taught, do not teach, or I studied, do not teach quantitative research methods for lawyers. However, in my case, I have an undergraduate degree in law. I'm a lawyer and I have a PhD in law, but I also have two master's degrees in politics. So that's where my training in other sort of research methods come from. And in fact, I have a book, my second book, which was an edit collection done with a colleague, Loveday Hodson. It's all about methods, and it's about the richness of methods that we have and the tools that we could use to actually explore law, in our case, international human rights law. And I think it's very important. I think it's very important. And I try to teach my students this, that it's incredible the amount of tools that we can resort to explore a legal phenomenon, and the finding that we can obtain when we approach the field from different perspectives, being then theoretical or methodological. So I think it's incredibly important to use a variety of these sort of tools in order to explore, because again, we manage to see things that you wouldn't if you were conducting a different type of research. And this, again, that doesn't take any value of any of the type of research. I think they're all incredibly valuable, but it's that. I think we need to be aware of the toolkit that exists and comes from the social sciences to explore law and legal phenomenon and take advantage of this.
So, as I mentioned earlier, your article focuses on procedural defenses that states have raised before the ICJs. Mostly objecting to the jurisdiction or the jurisdiction of the court or the admissibility of a claim. And procedural defenses can seem a little bit, or the study of them can maybe seem a little bit esoteric on their face, but I want to kind of highlight that, the ICJ and many international adjudicative bodies as institutions are constantly kind of fighting to stake out and maintain legitimacy. So when a state objects to the jurisdiction of the court, it's a serious matter for the court, and they have to kind of figure out a way to both maintain legitimacy and to also, try to evaluate objectively these defenses. So why do states kind of utilize these procedural objections, and what effect can it have on a case?
Actually, we titled the the piece the abuse of procedural defenses, but procedural defenses are incredibly valuable and valid tool of any sort of case, and they're very important for something that you are mentioning in particular, which is the legitimacy of the court. I think that on the one hand, the article shows that these defenses have been incredibly important, incredibly effective, and that shows that they are relevant. They have affected roughly, I think, 50%, just a bit over 50% of the cases. So they're clearly a valid tool of the defense in a given case. On the other hand, the court needs to allow for valid defenses to be presented and upheld them, because it has the responsibility of protecting its jurisdiction and its legitimacy. So even though the title might indicate that we feel somehow uncomfortable with these sort of defenses, in a big part, it's the opposite. Procedural defenses are extremely important, and that's why it's very interesting to research or conduct research about them and provide the or highlight the value that they have had before any sort of tribunals, but in particular international tribunals that are based on the consent of the parties. If the court was not to protect the scope of that consent, it will jeopardize its legitimacy and probably even its future. So I think it's incredible. This type of defenses are valid, are incredibly important.
So you just mentioned that these defenses have been, in your research, shown to be very effective, about 50%. Could you talk us through a little bit more of the results that you found from your research, and whether your findings surprised you?
Actually, they did, just because this paper was in a roundabout way a continuation of research that I had done many years ago. In 2012, I published a similar paper, or at least a similar on a similar topic regarding the Inter-American Court. It was also an empirical examination of preliminary objections besides the court. And out of normal knowledge, that having good knowledge about the jurisprudence of the ICJ, but not focusing when we tend to read, study, and teach about cases, we tend to focus on the merits of cases and what the law or what is established about the law, how the law has been developed or not in the particular case. We tend to ignore the procedural aspect of the case. So without knowing exactly what we're gonna find here, I proceed from the assumption that might be a similar picture to that of the Inter-American Court, and the results, the outcome shows that it's completely different. As I said before, I think that it has the defenses have affected roughly 50% of the cases. So some of the cases were about 50% of the cases were either dismissed or restricted in scope because of procedural defenses. They have been incredibly pervasive. I did not necessarily expect that. They're present in roughly, I think it was about 80% of cases, you do have preliminary objections. And yes, I think that probably the most interesting finding when we went to the actual numbers of objections that we found, because we searched for these objections not just in the judgments of the court. That was our starting point, until we realized, okay, we're missing a lot that might have appeared in pleadings, in both written and oral pleadings by the states, and that opened a bit of a Pandora's box, because yes, there were so many more than the ones that were known. It then started disclosing that even though they're very effective, they are very inefficient in their use, in the sense that states ended up, or many states end up raising a huge number of objections, only some of which end up being upheld by the court. So I think that this is the combination of numbers that we end up finding, or findings that we encounter that ended up being quite interesting, and in my case at least unexpected, considering what I have found in previous research.
And from your research, it's clear that some certain states, my own country, the United States included, likes to object a lot more than others. Are there common attributes of the states that tend to lodge objections, or what you call insistent objectors? What can this kind of tell us about global order, power dynamics, and kind of based on who's lodging these persistent objections?
We used it. We sort of coined the term insistent objectors in a play of words with the idea of the persistent objector in with regard to customary law. And what we use it is to identify within the case law of the court those states that had raised 10 or more objections in their appearances before the court. But the truth is that we found very different types of states. There isn't a specific type of state that will raise more objections. Yes, the US is the state that has raised the largest number of objections so far. It also has been involved in a relatively large number of cases compared to other of the insistent objectors. But there's no commonality. Like one thing that we actually thought about, because of our summation that we do as to, well, the concerns that we have about these type of defenses that might be dilatory in proceedings, ended up with much longer cases, much more expensive cases, is that okay? Are the states actually certain type of economies, and these are the ones that have the luxury if you want to raise these objections? But actually that's not the case. If you go to the list of the insistent objectors, you have large economies like the US, or let me think, Germany, you have the UK, you have India, but you have mid-sized economies. If memory serves me well, Colombia, Pakistan, and you have small economies as well. You have the poor countries in Central America like Honduras or Nicaragua, or you have some African countries like the DRC or Rwanda that have raised objections. Although I cannot, or we didn't explore this necessarily, but based on an empirical study that had been done quite a few years ago and published in the European Journal of International Law, what they might have in common, or what states appearing before the ICJ have in common, actually is legal counsel. There is a group of legal experts that tend to appear. So that might actually reflect or show some commonality. But this is not something that we managed to explore. So I cannot say this is the cause either. What I can tell you is that the other one that could have looked like a potential cause is not. Insistent objectors come in very different shapes, forms, and economies.
And so your kind of remedial solution to the issue of persistent or insistent objectors is that the court should adopt a firmer stance when they're faced with, as you say, costly dilatory tactics. I'm curious if you think in 2026, if the court feels like it has the leeway to adopt a stricter stance, and you know, uh, to what extent can parties use these objections to, the court is historically kind of conservative in its procedural and substantive rulings. To what extent can states just continue to take advantage of this?
That's a good question. I don't know if I have a good answer for that. Uh, but we do propose that the court needs to take a stance here. I don't think that, and in particular, I probably not so much with regards to procedural defenses, but we raise certain paradigmatic examples of really incorrect behavior before the court that the court has tolerated. And I think that this is detrimental to the legitimacy of the court as an institution. So I do think that on the one hand, the court can establish more clear guidance. And I think this is something that we strongly encourage in the article as to, okay, there are certain objections that do not have a role to play in jurisdictional admissibility. It might have a role to play elsewhere, perhaps in remedies. I don't know. But it doesn't really play a role. And we can see that in some objections that are consistently rejected by the court, have never been upheld. So the court could be clear here. The court even tried to do that regarding clean hands at some point of its case law. So it could do it more firmly and said like, okay, let's stop with this type of defenses because they're never going to be accepted. So let's stop wasting everyone's resources. The other one is, and it's something that has been written about, would be the possibility of some sort of code of conduct for anybody appearing before the court as it exists in the profession in every single country. That's another alternative that again has been written about that, okay, you need to behave in certain ways and should be consequences for those that do not behave. So I think these things are possible, and I don't necessarily think that it will cost the court that much. I think that the court obviously has to deal with very difficult cases, and in the later years, I think this is becoming more evident and a bigger focus of attention. But the court needs to uphold its role. This is probably the most important court, or in many aspects, the most important international court that exists. So I don't think it can hide away from, like, I don't know, establishing certain criteria to be followed.
In other words, it may in the long run hurt the court more not to take a firmer stance.
Likely, yes. Again, I don't know if it necessarily does immediately, but yes, I don't see what they're really gaining by not to, and I think that yes, it could have some sort of loss of authority if it allows certain type of behavior. And again, regarding procedural defenses, this is probably a small issue compared to others that the court has experienced, some of which we also mention in the article. And yes, I think that there is something to lose by not taking a stance. I agree there.
Well, moving into our wrap-up portion of the interview, I was wondering if you could recommend one piece of media on international law, book, article, or even a movie or TV show. What would it be and why?
Well, obviously, wouldn't recommend anything I have written because it will be probably inappropriate. But I would obviously recommend something that a co-author of mine has written. For me, one of the most inspirational books I have read of international law, and I have a colleague that actually had been there for the oral delivery of it, as is Antonio's 2005 course of the Hague Academy of International Law, his plenary course, which was International Law for Humankind, I think it's called. It's about the humanization of international law. And I think that even 20 years or 21 years from that course, it remains incredibly important. Something non-academic, which I tend to recommend my students, is well, now it probably would sound as an old movie, but there was a parody in the late 90s that it's called Wag the Dog, that had Robert De Niro and Dustin Hoffman. And it's always applicable movie to understand how domestic politics in particular play an important role in international relations and international law. I think that's an easy watch that is really telling and has kept he continued being very current even 20 years from 30 years from then. Oh goodness, yeah.
Our final question, what would be your advice for a law student who wants to publish a sharp original work of legal scholarship?
A few things. The first, to write about something you're truly curious about, something that you are really keen and passionate to explore, where you want to know more about and where you think you have something to contribute. Another thing would be to engage whatever has been written about the topic. It's very important to in academia to engage in this conversation, what others have said about this, and in particular, what's the gap that you identify of what has been said about the topic. And lately, don't be afraid of ruffling feathers. If you are honest, that if you're actually quite caring about what you're writing, you can disagree with the authority, even that being established academic or being a court. You can have a voice as long as that is grounded and is justified. You don't need to be following what has been said before. In fact, what is said before, identifying that gap is probably what makes one of the most important elements of an impactful article.
Great. Well, Damien, thank you so much for joining us for another episode of the MJIL podcast. We're really looking forward to sharing your article. It's titled Insistent Objectors, the Abuse of Procedural Defenses Before the International Court of Justice. So thanks so much for joining us.
Thank you very much, Ryan.
All right, take care. Great.